Proceeded from there, Ms. Flaherty's friend asked questions.
Stan, I think what Justice Quintero is asking, and my concern too, is assuming it is error, what is it about that statement that affected the guilt in any way, or might have, understanding the threshold is very, very little to show harmful error.
I understand. Again, the short statement is it did affect the verdict. Here's how it affected the verdict. Because right from the very beginning, the prosecutor in this case, who was the same prosecutor in Lamar Brooks, I'm sure you recall Lamar Brooks' case, the same prosecutor in that case was in this case. And from the very beginning, in his opening statement, within the first minute of his opening statement, he focused on this phone call. He focused on the phone call and said, you're going to hear about this phone call and how it provided the motive. And from his opening to his closing,
Is motive actually necessary to be demonstrated in a murder case such as this?
No, it's not necessary, but this prosecutor bragged in his closing argument about how he did prove motive and how this phone call proved the motive, and it became a feature of this trial. And it was the only reason that this prosecutor offered, and that the evidence could show, the only reason why this may have occurred was as a result of this phone call and this argument. And he focused on it, and he let the evidence that was presented for two other men would have been the statements on the 911 phone call. There were no eyewitnesses. There were no witnesses that came forward and said they saw two other men there. But to attempt to answer your question, it's because this prosecutor focused on it, and it was a feature of the trial on how this phone call was the only reason, it was the only evidence presented as to a reason for the murders, for the deaths. It was the only reason. All the evidence showed that this family got along well, that Mr. Hutchinson treated these children as if they were his own, that he loved Renee, that they very rarely fought.
Are you arguing that the trial court gave too much weight to this? Is that
well, I don't think the trial,
because it appears in both those contexts that you feel it should not be given substantial weight?
The aggravated child abuse aggravator?
Right.
I don't think, based on my reading of the court, I don't think he considered the aggravated child abuse as an aggravator.
All right.
I think he considered...
Just the under 12.
Right. But there is still that issue, and I know Chief Justice Anstead has discussed that.
We appreciate your candor.
Thank you.
In that regard. Okay.
Can you... In part, but also in part speculated, such as that Jeffrey would have heard the chilling sounds of the shotgun shells being racked into the chamber. That's pure speculation. There was no evidence offered in this trial to indicate that Jeffrey could hear.
Was he?
But I would like to talk about the burden-shifting comments he made, the vouching for the credibility. There were 3 instances in his closing when he said, regarding the 911 call, he said that these people came in here and told you the truth. He said that 3 times.
How much of this was objected to?
Those were objected to. Those comments were objected to. The burden-shifting comment, the vouching for credibility comment, and the golden rule comment. And I'll sit down and reserve the remaining 10 minutes I have for rebuttal.
Thank you very much.